I came to the UK on a skilled worker visa as a carer. Can I do a side hustle? Am I allowed to start a company? Will this affect my care visa? Will it affect my settlement visa? As a care worker in the UK on a skilled worker visa, your permission to live and work in the UK is directly tied to your employment with a licensed sponsor. You must remain in full-time employment with the specific employer who issued your certificate of sponsorship, and this role must match the job code under which your visa was granted, typically care work under the health and care worker route. For the year 2025 to 2026, the minimum salary requirement for care workers under this route is £25,000 per year. As long as you continue to meet or exceed this salary threshold and your job role remains genuine and compliant with your visa terms, you are considered to be fulfilling the main conditions of your visa. In relation to additional work or business activity, the skilled worker visa does permit self-employment under strict conditions. You are also not allowed to run a business as your main job or in any way that replaces your sponsored employment. However, there are certain allowances for supplementary work. You may work up to 20 hours per week in a second job provided that the job falls under the same occupation code as your sponsored role or is on the immigration salary list. This supplementary work must take place outside of your contracted hours and must not interfere with your main employment. Regarding starting a company, it is possible to register a limited company and to be a director or shareholder in a UK business. However, this must not breach your visa conditions. You must not derive your primary income from the business. Any role in the company must remain minor and must not interfere with your primary care job. The business cannot become your main occupation, and you must not pay yourself in a way that amounts to self-employment. The Home Office scrutinizes skilled worker visa holders who are involved in business activity, and any indication that your main focus has shifted away from your sponsored employment could lead to enforcement action or visa curtailment. When it comes to applying for indefinite leave to remain after 5 years, your entire immigration history is considered. You must continue to meet the salary threshold, remain employed in a genuine job with your sponsor, and not have broken the terms of your visa, including restrictions on employment. In addition, you must not have spent more than 180 days outside the UK in any 12-month period during your qualifying 5 years. You will need to pass the Life in the UK test, meet the English language requirement at level B1 or higher, and demonstrate good character. This includes showing that you have not committed any immigration breaches such as engaging in unauthorized self-employment or working outside permitted conditions. Any breach of your visa conditions, such as running a company in a way that amounts to self-employment, or working in an unauthorized role, could lead to refusal of your settlement application. The Home Office takes such matters seriously, and once a breach is identified, it could also lead to your visa being cancelled before you even apply for settlement. To ensure compliance and protect your immigration status, it is advisable to maintain clear records of your work, avoid any business activity that might breach your visa terms, and consult with a qualified immigration solicitor if you are unsure about any aspect of your employment or business interests. Starting or running a company may be legally possible, but it must not interfere with your primary role or result in any violation of your skilled worker visa conditions. Remaining compliant with your visa rules is critical not only to keep your current status legal, but also to build a strong and successful application for permanent residency in the future. For assistance contact Tan Law Solicitors on 02477632323, WhatsApp 07421429338, email andrew@tanlaw.com.